is now ordered and decreed as follows. He says, after considering the email submissions today, it is ordered that the defendants, so in this case the government, shall have until Wednesday, which is 2 days from now, enough time to set forth a brief and what factual basis they have, if any, against allowing the 3 forensic inspections. So if they have a justification for why these should not happen, why is that? Let us know. It's due by December 2nd at 5 p.m. Let us know. The brief should be accompanied and supported by an affidavit or other evidence if appropriate. So send us the evidence, Mr. Government. If you don't want us to inspect this stuff, tell us why. In addition, the judge also says the defendants, so the government here, they're enjoined and restrained from altering, destroying, erasing, or allowing the alteration or destruction or erasure of any software or data on any Dominion voting machine in any of those 3 counties. Pretty good. Pretty good. So hang on to that data and tell us why we shouldn't be looking at it. But hang on to it while you're writing your motion. In addition, number 3, defendants are ordered to promptly produce a copy of the contract between the state and Dominion. So some government records about what that looks like. And then lastly, this temporary restraining order shall remain in effect for 10 days or until further order of the court, whichever comes first. So this is important, this is pertinent here. 10 days, so this temporary restraining order is going to be in place from 10 days. This is the order. This came out on November 29th at 10:10 p.m. Eastern Standard Time. So this judge was up late and issued this order late that night. Okay, and it says 10 days for the restraining order. Well, then what ended up happening is shortly thereafter, now this was the big headline across the internet. Everybody, oh my goodness, Pennsylvania judge, Team Trump victorious, because they're going to, they issued all of those orders and this is going to be very great. Well, then shortly thereafter, there was another order that came out, and it was actually on the second day, the following day on November 30th, the judge came out and said, hold, not so fast. There's actually a little bit more to this than meets the eye. This is the second order that came out. It says, this court finds on November 29th, we already granted a prior order here, but this order involves a question of law, and there's substantial ground for a difference of an opinion, and an immediate appeal may actually be necessary here. So this is called interlocutory appeal under USCA 1292B, and what that means is this judge is basically saying, okay, yeah, I know that in that last order, there's a pretty important issue here that an appeals court may want to take a look at. And it may have to do with amending the complaint to add in the different defendants. It may have to do with some of the relief that's requested and so on. And so they're saying that right now, if the defense wants to appeal this thing, they can take it up to the next level. They can take it up to the circuit court and go and appeal it. But if you read this order, it's not saying anything about undermining the underlying complaint or the underlying order, right? This order on November 29th says it's going to remain in effect for 10 days. But then another order comes out and doesn't say anything about that. It just says you can appeal this sucker up to the next circuit court level. And then when we move on to the final order, we're going to see here that it says, again, no comment, no mention of what happens to the underlying injunction. That 10 days is still going on. But here it says this matter shall come to the court for a hearing on Friday, December 4th now. So now there's going to be an evidentiary hearing or some sort of a hearing on the 4th this week. And then the schedule here is going to be opposition to the plaintiff's complaint due on Wednesday. We're going to see a reply brief on Thursday, and then we'll have the actual court proceeding on Friday. So it's going to be a busy week. So that means the government has to respond by Wednesday. Sidney Powell and her team have to respond back to their response by Thursday. And then we're going to have a court proceeding that takes place on Friday. So what that means is that Georgia is going to be lit over the next week. So expect to see a lot of new filings and a lot of new back and forth on this particular case. I saw that this afternoon that the Democratic Party, the DNC, the DNCC, the S, whatever, all the different acronyms are joining into this lawsuit. They filed a motion to intervene. Looks like the judge granted that. I briefly read through their response to the complaint. Their arguments are largely the same, not particularly much interesting there. A lot of standing arguments that there's no basis for bringing this complaint, a lot of moot arguments that this stuff is over because the state has already certified this, and so on. So not particularly worthwhile in terms of dissecting those. I think we've already done enough of that. But speaking of legal claims and new time since we studied them in law school. We're talking about the Supreme Court of Pennsylvania very recently issued an order dismissing a lawsuit with prejudice. And you may remember this, well, we talked a lot about Pennsylvania. It's hard to keep track of them. But this is the case that we want to highlight here today in the Supreme Court of Pennsylvania in the Middle District. Again, this one was filed by the Honorable Mike Kelly, who is a local congressperson, and he was suing the Commonwealth and looks like the Kathy Boothbart, who's been the subject of a lot of Pennsylvania lawsuits, basically most of the year. And what we see here is this was an order. This was called what's called a by curiam opinion here. So you can see at the top, by curiam opinion means it's by the court. So when we get to the final page here, we're going to notice that this was not signed off on by any particular judge. And you can have some commentary about that. You know, whether no judge wanted to put their name by this thing, everybody's hiding sort of behind this court order, you know, and we're all just going to go along here, but nobody's going to take primary responsibility for this thing. And to frame this out just a little bit further, in Pennsylvania there are a lot of lawsuits that have been going back and forth for some time. Some are on the door of the U.S. Supreme Court. Some are in federal court. This one here is in state court. So this took place where a local congressperson was suing the government. It was in a lower level court, and the lower level court prevented the certification. They issued an order regarding the certification of Pennsylvania's votes. Okay, so this was lower levels. This was not Supreme Court. This was sort of an entry level court in Pennsylvania. Lawsuits get filed. Lower level court says, yeah, you're right. This mail-in ballot thing here, it's a problem. We're reviewing the documents, and it's looking like this whole thing may be unconstitutional. You mean like absentee mail-in ballots? No. All of them. The whole thing. Because of what happened with Act 77, which we've already spoken about a long time for at length on this channel. There's been a lot of litigation about this act, but let's run through this high level. So when we break it down a little bit, there was a lower level court in Pennsylvania that said Pennsylvania is not going to certify our elections. The lower court said that. The Supreme Court out of Pennsylvania, not the United States, came in here and issued this order over the weekend on the 28th of November. Here's what that order says. All right, pure curiam. So this is an order from the court in general. It says on now, November 28th, we are taking jurisdiction over this. In this case, Commonwealth of Pennsylvania and the Secretary, we vacate the lower court's order, which had originally preliminarily enjoined the Commonwealth from taking any, okay, let me back up on this. They're ordering here that any further action regarding the certification of the 2020 election result is gone. Then they're going to be dismissing the entire complaint altogether. We're going to dismiss it with prejudice. And you can see in this footnote that they're taking jurisdiction over this. The court is saying on its own motion or on petition of any party, any matter, it can just go in and just take power. And that's what it's doing here. It's saying we're going to step in on this thing because it's so important. They go through, and you're going to see the rest of the outstanding motions are all now dismissed as moot. So this is the takeaway from this opinion. Let's go into the analysis here. So what they're saying is that they're challenging Act 77, which was passed into law in 2019. And what that act did is it established universal mail-in voting for Pennsylvania. Now they're saying they want to find that to be unconstitutional. So Trump's people are coming into court. They're saying that act that was passed in 2019 is unconstitutional, and what they want to do as a remedy is to prevent the certification of the results out of Pennsylvania. They're asking the court to invalidate, and this is the court's summary of what the plaintiff's arguments are. So what Team Trump, what they're arguing, it's saying they're asking to invalidate the ballots, and they're asking to disenfranchise 6.9 million Pennsylvanians, and they're using language that comes directly from Donald Trump and his team's underlying lawsuit. They go on to the Supreme Court out of Pennsylvania, and they say, we hereby dismiss with prejudice for failing to file their constitutional challenges in a timely manner. The challenge violates the doctrine of laches, given their complete failure to act with due diligence in commencing their facial constitutional challenge. All right, hang on. While ascertainable upon Act 77's enactment. All right. This is nuanced, boring legal stuff. but let's keep mustering through this. They say the want of due diligence demonstrated in this matter is unmistakable. Petitioners filed this facial challenge more than 1 year after the enactment of Act 77. So they filed this action on November 21st, which is going to be after the election. Millions of Pennsylvania voters have already expressed their opinion in both June and November elections, and now they want to commence this litigation, and that is beyond the pale. The petitioners failed to act with due diligence, and this would result in the disenfranchisement of millions of Pennsylvania voters. As a result, they're going to be saying that they are listen to how broad this is, preliminarily enjoining the Commonwealth from taking any further action regarding the certification of the results of the 2020 election. So no other further action regarding the certification of the results. And they're going to dismiss with prejudice petitioners' petition for review, and all other outstanding motions are dismissed as moot. All right, so let's break down what the court's understanding here is. So they're saying that Act 77 was broken down, was passed into law in 2019. Okay, so they should have filed their lawsuits right after it was filed. They can't wait now until after the election is over. They should have challenged Act 77 before then. And so what they're saying, presumably, is that Act 77 has been the same as it was in 2019. We already had a primary. We already had a primary for the presidential election. We had other primaries and so on. So they should have challenged previously because Act 77 hasn't really changed. It's been the same this whole time. There are no new issues. There's no way that we would have known, or you should have known, that you should have known about these issues because the act was so set in stone. But did the Supreme Court of Pennsylvania forget that on September 17, 2020, so over a year later, that they changed Act 77? Remember this? We covered this one a long time ago. This came out September 17th before the election out of